The matter of Armstead against Royal & Son Alliance Insurance Company Limited.
Lord Burrows will hand down the judgment.
This case concerns a road traffic accident in which a car was damaged. Although the sum at stake is only £1,560, the decision has the potential to affect a significant number of other cases. It also raises some fundamental questions in applying the tort of negligence. The claimant, who is the appellant, Lorna Armstead, was unlucky enough to be involved in 2 road traffic collisions within a short space of time, neither of which was her fault. After the first collision, while her car was being repaired, she hired a car, a Mini Cooper, from a company called Helphire Ltd on credit hire terms. The business model of credit hire companies is that they rent out a substitute car on credit to an accident victim believed not to have been at fault, while the victim's car is repaired. The hire company seeks to recover the hire cost on behalf of the victim from the other driver's insurers and only looks to the victim for payment if the claim fails. In the normal course of events, this enables the accident victim to have the use of a hire car for which she does not have to pay. The hire agreement between Helphire and Ms Armstead was on Helphire's standard terms, which included an obligation on the hirer to return the car in the same condition as it was at the start of the hire and to indemnify Helphire for any damage to the car. Most significantly, for the purposes of this appeal, there was a term in the agreement, Clause 16, under which if the hire car was damaged, the hirer was required to pay the daily hire rate up to a maximum of 30 days for Helphire's loss of use while the car was being repaired or awaiting repair and was therefore out of use. While she was driving the hire car, the Mini, Ms Armstead was involved in the second accident when she was hit by a van that was being negligently driven. She brought a claim against the insurers of the van driver. She sought damages for the cost of repair of the Mini, but also for the sum under Clause 16 that she was contractually liable to pay Helphire for its loss of use. I shall refer to this as the Clause 16 sum, which is agreed to be £1,560. The Deputy District Judge dismissed her claim entirely on the basis that as she did not own the hire car, the Mini, all her loss was what the law calls pure economic loss, which is irrecoverable in the tort of negligence. On appeal, the recorder held that she was entitled to the cost of repairs, but not to the Clause 16 sum. The question as to whether Ms Armstead was entitled to damages for the Clause 16 sum was appealed by her to the Court of Appeal, which dismissed her appeal for several reasons. These included that the Clause 16 sum was irrecoverable pure economic loss, and that because Clause 16 did not represent a genuine and reasonable attempt to assess Helphire's likely loss from not having the use of the hire car, the loss claimed was not reasonably foreseeable and was therefore what the law terms too remote to be recoverable. Ms Armstead now appeals to the Supreme Court against that decision that she is not entitled to damages to compensate her for the Clause 16 sum. The Supreme Court unanimously allows her appeal. The leading judgment is given by myself and Lord Leggatt, with whom Lord Richards and Lady Simler agree. Lord Briggs gives a short concurring judgment in which he agrees with the majority's reasoning and conclusion, but prefers to rest some aspects of his decision on a concession made on behalf of Ms Armstead without determining the legal correctness of that concession. The Supreme Court makes clear that the loss in question was not pure economic loss. Ms. Armstead, as the hirer of the car, who the law refers to as the bailee, had a possessory interest in the car, so that her contractual liability to pay the Clause 16 sum was economic loss consequent on damage to the car in which she had a proprietary or possessory interest. By definition, that is not what the law means by pure economic loss. Furthermore, the loss was not too remote, because the defendant insurers had failed to prove that the clause was not a genuine and reasonable estimate of Helphire's loss of use. The decision of the Court of Appeal in the earlier case of Network Rail Infrastructure against Carnarvon Group in 2011 was examined and explained. In that case, damage caused to a railway bridge by a negligent driver meant that Network Rail incurred a contractual liability to pay train operating companies for their loss of use of the railway lines while the bridge was being repaired. The Court of Appeal held that Network Rail's contractual liability to pay for the loss of use was recoverable as damages and was not too remote. The Supreme Court here affirms and applies that decision. In deciding that the Clause 16 sum in this case was not too remote, the Supreme Court considered it important to decide who has the burden of proof in respect of remoteness where a tort has been committed. That question has not previously had a clear answer. After considering various authorities in respect of principles limiting damages that are closely related to remoteness, such as legal causation, the duty to mitigate, and contributory negligence, the Supreme Court concludes that the burden of proof in respect of remoteness where a tort has been committed is on the defendant. Here, the defendant insurers had not discharged that burden. That is, they had failed to show that Clause 16 was not a reasonable pre-estimate of Helphire's loss of use. Ms. Armstead is therefore entitled to damages for the Clause 16 sum, and her appeal is allowed.
Thank you. The court is now adjourned.